Right, we now come to Bernie Atwell, who's going to talk about licensing and copyright. And if you forget everything you've heard today, the bit that you must forget last of all, or remember above all else, is what Bernie's about to tell you, because it really is the core of what makes OERs work. Over to you, Bernie.
Thank you for inviting me. Yes, I'm Bernie Atwell. I worked at the Open University. I've retired now for many years, and when I worked here, I was their deputy head of intellectual property. The Open University has always been unique with regard to copyright and rights. It's in that it's always had its own dedicated copyright rights department. Not only that, it's always had experience in dealing with multimedia content. So when universities started to go digital and were able to incorporate different types of content, lots of educational institutions struggled with all the different types of contracting issues, particularly if they were going to do with music, actors, taking vox pops in the street, that sort of thing. That was new to a lot of educational institutions. That was never new to the Open University because it always dealt in presenting its students through a variety of media, and particularly through its relationship with the BBC. We did broadcast to our students, as you know. So we were very lucky in that we were able to amass this lots of experience in dealing with different contractual issues across our media. And if I can, I'll share some of that experience with you in the short time we have. What I'm going to do today, I'm going to introduce copyright right at the base level, and I'm going to assume none of you have any knowledge of copyright. I apologise for those that do have lots of knowledge and can share with it, but it puts everybody on a level playing field. Then I've got a little exercise, and you'll be glad to know the little exercise is not online, it's offline. I'm so low tech, I'm so on-techy, and I was so glad that none was struggling a wee bit because none's very techy. So that gave me a wee bit more confidence. And any advice, if you ask me as many questions as you like, and any advice I do give you, even though it'll come across in an informal way, it's actually based on the UK Copyright Designs and Patents Act. So any advice I give you is based on this, not only this, but case law as well. This book, I don't know if any of you work with it, but it's quite bland, just black and white information. But when I'm dealing with giving advice on copyright, we have these big tomes of case law, and we operate within that. So we're going to create a card today here. If you can help me do that. And given the time of year it is, Christmas out of the way, coming into February, and what happens during February? We have Valentine's Day. So we'll create a Valentine's Day card for all us romantics here. And you can help me do that. So I have only 3 colours to work with. And I want you really to be imaginative in this card. Really, you know, with creative abilities. We have somebody with a design background and everything, haven't we, down there? We can just throw in. Because I am the world's worst drawer here, as some people will know. So this is if you imagine our Valentine's card, this is the front of it, the front of the card. And then after that, we'll go inside, which is usually sometimes the most interesting bit. However, the front of it, what would you like to see on this front of our card?
Red hearts. Some red hearts.
Red hearts, oh, I can do that. A few red hearts. Yeah, a few. That's a heart, isn't it? Shall we do a couple of red hearts then? That'll do, won't it?
You could put the hearts in a heart shape.
Hmm?
You could put the hearts in a heart shape.
Oh, put the hearts in a heart shape? Like that? Yeah. Okay, we can do that. Something else then. Cupid.
Or just the word love will do.
Cupid's like that, isn't it?
Just the word love.
Just the word love.
Yeah, somewhere on there.
Where? Anywhere?
At the top.
Oh, we'll use a different colour. We'll use a different colour. We will put it. We'll put a Cupid here, and we can, you know, as a Cupid, right? You know, we can use our imagination. Anything else on there?
Flowers. A guitar. Flowers.
Flowers, right, sorry. Different accents here, Irish and English. Right, flowers. Let me see now, we'll put flowers. That's okay. Okay.
The violin.
The violin. What did he say?
A violin.
Yeah, I thought you said a violin. Yeah. Oh.
You have the violin plus the flower on that, the roses.
A violin's something like that, isn't it? It's like a guitar, isn't it? Yeah, but that's a violin. Is it? Mm. Okay. Maybe that's enough on the front, is it? Are we happy with this? Yes? Oh, I know. Anything else we want before I turn the page? We've got just love there. And we've got heart of hearts, a violin, Cupid, and we've got a bunch of flowers.
My Valentine.
My Valentine. Yeah, that's nice. Okay. I think that looks good now. I'm really pleased with that. Okay, so that's our first. Now in here, you can be even more creative. What you'd like to see in this card inside, the most fundamental thing we would have inside is a verse, wouldn't we? We'd have a verse for Valentine's Day, wouldn't we? Shall we put a... We have some non-romantics here, haven't we? You buy into the shops who are just out to make money. Right. We'll put a verse. Can somebody give me the first line of a verse? Just anything.
Roses are red.
Roses are red. Yeah. Another line.
Violets are blue.
Hmm?
Violets are blue.
Goodness. All right. We need a couple of more lines here. Roses are red, violets are blue. Something a wee bit original.
Your eyes are yellow.
Your eyes are yellow. Shall we put that? Could be a funny Valentine, couldn't we? Roses are violet and blue. Your eyes are yellow. Go and see a doctor. Or I'll dump you.
Or is it just blue?
Yeah, that's a nice one. Or is it just flu? Yeah. Right. So we've got a nice verse there. Well, no. What else would we have in there? You open up your card. What would you think? You have lots of cards these days when you open them up.
Okay, we'll have a classical music song.
They play music.
Adagio G minor?
God, it's very highbrow for a very lowbrow card. So we've got music. It opens up and we've got music. Guy, what did you say it's playing?
It's Adagio in G minor.
How do you spell the Adagio?
A-D-A-G-I-O.
J-I-O. Right. Okay, that's quite nice. Adagio. Anything else we'd like to see in our card inside? Any photograph? Signature?
Well, you already said so. You might sign it. You might.
Yeah. What sort do you get? Do you get it with a question mark?
Maybe sign your
I get one from my husband. He puts a question mark on it. Either way. Anything else? Any photographs or anything? Any?
The picture of the new digitally enhanced Andrex puppy.
Oh God. Yeah. Okay, that's a puppy.
Very big dolphin eyes.
Andrex puppy. Okay then, anything else?
Perfume scratch bag.
So we targeted our audience in that it's perfume and that this is a card for a lady then. More or less, you can't tell these days. But so we've got a perfume scratch pad and we've got some music playing. We've got our verse, we've got that. Are we happy with this card? Yeah. Well, as easy as that, we have created a copyright work. We've created a copyright work that is protected under UK copyright law. To get it protected under UK copyright law, you have to fulfill a few criteria. One of that criteria in that our work has to be fixed. It's fixed in writing or otherwise, and we'll agree that that's fixed. And it needs to be original. Now, the originality threshold in the UK is very, very low. That's why this can get protection as a copyright work. But the originality means that basically you have not copied your work from anyone else. So you can go into W.H. Smith's and you can see lots of cards that would be practically similar. They could even be the same in lots of ways. And they could each be granted copyright protection because they weren't copied from another work. We could each go and take a picture of the Eiffel Tower and they might be exactly the same, more or less, and they would each be capable of copyright protection. That's the level of originality is required in the UK. Now, for databases, which is part of a literary work, which I'll show you just as I go through the slides later, the originality threshold has risen a bit. We're not talking about databases today, but I'll just let you know that the originality threshold is a bit higher. It has to reflect the intellectual input of the author. But we're not talking about that today. I'm just whizzing through some pointers. To get copyright protection in the UK, you don't need to register your work anywhere. The fact that it's fixed, that gets it protection. Unlike patents and trademarks, which does go through a registration process. Copyright does not. And when I said I was deputy head of intellectual property, copyright is an intellectual property. The other intellectual properties are patents, trademarks, and also they would put in there sometimes confidentiality, that sort of thing. And when people talk about intellectual property, that's generally what they're talking about: copyright, patents, trademarks, maybe a level of confidentiality. Today we're sort of focusing on copyright. You don't even need to put the C in the circle to get copyright protection in the UK under the Berne Convention that the UK signed up to. It means no formalities, and one of the no formalities is you don't need the C in the circle. So if you're ever looking at copyright works and there's no C in the circle, don't even start to think it may not be, it's in the public domain, or it's somehow not protected by copyright. You don't need the C in the circle. Of course, it's good practice, as we all know, to put the C in the circle with the owner there. There's another convention that the UK signed up to, and that's the UCC. There's the Berne Convention and the UCC, Universal Copyright Convention. And under the UCC, you do need the C in the circle. But most countries are all signed up to the Berne and the UCC. And as you know, good practice sense means that you would put the C in the circle. But you actually don't need it. Now, whilst we have, as quickly as that, created our copyright work, it's no different in lots of ways when we're putting together resources in a course or putting courses together, in that we have used and we've put assets in, say, in our card or in our course. And before we would exploit them, obviously we'd need to clear the rights. We'd need to get permissions for any third-party content that we would put in our product, course, whatever, before we can exploit it either to our students or in any way that you have identified for your institution or business. And just looking at our card, what is the third-party material that you think we'd need to clear before our card gets put on that shelf at W.H. Smith's? The music.
He's recording the music rather than the composer, right?
Well, the music we've got classical music. The music itself, would that music itself be out of copyright in terms of the actual composition? Hi, Adagio, how old is he?
19th century.
Right. So his composition is out of copyright, and we'll go through durations at the minute. But when you're dealing with music is multi-layered, and every layer is capable of copyright protection. So you mentioned a recording. We'll assume for this purposes, for our card, we have got a recording that's in existence. So you have the recording, which is capable of copyright protection, therefore needs to be cleared. You have the lyrics, if there are any, capable of copyright protection, needs to be cleared. And for this, we would say there are no lyrics in this, our music. And you have the music capable of copyright protection, and you have the performers. Now, for our recording of Adagio, G minor, we've got a recording. It could be a recent recording. We'll say there's no lyrics, so that's out. The music itself, we'll say, is out of copyright, and if there are no adaptations, that sort of thing. And we have the performers. The performers would be, we'll say, the orchestra who is performing this musical composition. So if you sort of try to get a handle on the layers of copyright in music, particularly if you're dealing with older recordings even, you can quickly start to get rid of the layers that you know don't exist or are out of copyright when we go through the durations. And in this instance, what we need to clear is the recording and the performers. The recording could be held by the record label, and generally you would go to them first and start to clear music. But either way, when you're dealing with music, and MCPS, Mechanical Copyright Protection Society, they're on the net. They can give you loads of information if you ever wanted to use music, and put you in touch with what they call library music. Library music is just a whole bank of music available. You probably have to pay for it or get a license, but you know you can use it in any capacity, and it's not going to cause you any rights issues further down the line. Music, even for the Open University, can be quite problematical depending on the type of music we're using. Commercial music, the Beatles and that sort of thing. So music, if you want to use music, it's good to have a discussion about that. MC, yeah, Mechanical Copyright Protection Society. And they can give you licenses for online use and that sort of thing, depending on your projects. They're very good, very knowledgeable to talk to. So we've dealt with that. Anything else that you think we'd need to be dealing with? Right. Where did you say you got that from?
Off the internet.
You just got it off the internet and you just enhanced it. So what would you're assuming, rightly, you'd need permission to, yeah, you would. Obviously you'd need permission to use it and you'd need permission to adapt it. And it's likely if you were adapting something maybe so well known, or depending on how the Andrex brand fitted in, you would need to deal with that pretty early on and not assume you're going to have permission to do that. Anything high profile.
How far would it need to be adapted or changed digitally before you could say actually it's no longer covered by the original copyright, it's a new product, a new artifact?
You'd need to adapt it so it's completely unrecognisable from the original. So you could have the puppy and that could just inspire you to make your own complete adaptation.
So give the puppy devil horns, that's not enough?
I wouldn't have thought so. If that particular image is so identifiable, just by sticking the horns on it would not make it. It's one of those things you judge sometimes as you go along. Like the Mona Lisa. Oh, Mona Lisa's out of copyright. But Mona Lisa has just if you just took the eyes and the smile of the Mona Lisa, the Mona Lisa smile is just so distinctive. That sort of thing. But more experience you have, you do get a feel for adapting and changing stuff. And the Open University does that quite a lot. But generally speaking, it does have to be completely unrecognisable from the original. The perfume. If this is perfume, scratch pad, we're assuming this is a brand thing as well. So that would need, it's likely perhaps that you would want that brand to buy into this product that we're producing because of the kudos it's going to bring both parties. Any brand issues obviously needs a big discussion at the start. And depending on the type of card, if they thought this was, tacky, maybe the perfume's tacky as well. I don't know. But either way, it's a brand issue and it's a collaboration of brands, no different than institutions working together or using logos and things like that. You would really need a clearance and some sort of, that would indicate some sort of collaboration, obviously. So you would need to sort that out. Anything else?
I have a question. You said we needed to ask for permission to use the picture, right?
This picture?
Yeah.
Because, yeah.
Yeah, and how? If it's like someone who is not famous and we just found it on the internet, can you just contact the person? And what kind of paper do you have? Well, are there forms to fill in? Or just an email is enough, and depending on who you deal with.
Well, that is pretty high profile, so that wouldn't be an issue. Again, if you were looking for images off the net and they were accredited to a well-known agency or stuff, then you would know where to go to. It could be Getty, whatever. You would know because it would be there. If you came across a generic image, it could be a dog, it could be a cat, I don't know, and there's no identifying features there whatsoever, then you have to make a decision based on your knowledge and experience of how generic this image is. Maybe I'm just going to use it. And again, the more knowledge you have of copyright, the easier it does become to make decisions like that. And through experience, you find, I use generic images all the time, even sometimes little figures from publications and things. We might just use without clear, although we would acknowledge. Even if you ever get into a risk situation of using stuff that you do know the source of, but for one reason or another, you judge you're not going to clear it, you've decided to go with the risk, you must always acknowledge. Don't ever not acknowledge, because that's very bad practice. And obviously you could be accused of passing off or plagiarism or whatever. You must always acknowledge. Okay, we'll get on to re-exercise in a minute. So we've got our copyright work. We have cleared all the rights issues. The bits on the front.
Roses are red, violets are blue, copyright.
Well, it might be, those words might be sort of insubstantial, but we'll get on to that in a wee minute. We'll get on to our poem in a wee minute. But first, we've dealt with all the rights issues. We're going to market our card. We've got a W.H. Smith just waiting on the sidelines to grab it for us. And whilst I said you don't need to put the C in the circle, we've created who actually owns this work that we created? Who can put the C in the circle and get all the money from W.H. Smith? Who owns this card that we put together? A group of us, because we all contributed. Any other ideas? The OU? But I'm here at the minute. But maybe by the OU you mean the employer?
School.
School?
You were the one who fixed that on that piece of paper. Does that have any value?
So,
for you personally, I mean,
me
as an individual, because you
and you think
actually admitted to pay. I don't know. You have any particular?
We'll put Bernie here, shall we? Okay, that's very interesting. The reason I do this is because this is actually quite fundamental to some institutions. Quite often in institutions they get involved in collaborations, get all the way down the line, everybody's working together, and they actually haven't sussed out who actually owns the copyright because they're all in a collaboration. So it's quite fundamental that you sort this out more or less at the beginning. Any copyright about any project, OERs, everything, always have copyright and how it's going to be handled on the table. Right. Yeah, you're right, Bernie. Straight away, Bernie is the first owner of copyright. The author is always the first owner of copyright. Bernie is the one who, me, fixed it. You gave me lots of ideas. Thank you very much. Ripped you off. But there's no copyright in ideas. And I took all those ideas and I'm going off to make a fortune with this card. So in the absence of any contract, which I just mentioned, we didn't have an agreement between us. Hey, Bernie, you're going to do all this. We're all going to join in. Can we have a contract about copyright? There was no arrangement like that. So I'm the first owner of copyright. Now, in an employment situation, the author, the employer would be the first owner of copyright. But anything you produce in the course of your employment would rest with your employer. That's not the same as what you do from 9 till 5. It's actually what you do. You're employed to do that type of work. So if you're working in any collaborations, you have colleagues that have got a particular talent. for taking photographs or whatever. And that is not their day-to-day job, even if they did it during the hours of contract, say 9 to 5 or whatever. Always get into the habit of doing waivers. And a waiver is such a simple thing, even with colleagues. If they pass over photographs to you, get them to sign a waiver for, they can assign copyright or they can give you a license. A sign in copyright needs to be done in writing like a contract. I couldn't say to you, oh yes, you can have copyright in that card. It doesn't work like that. I could say to you, you can have a license to use that card in a particular way. And that's generally okay, depending on what sort of business you're in and how you're licensing your content. But not copyright doesn't transfer that way. The copyright wouldn't rest with a group because the group needs to be a legal entity. I'm a legal entity. We all are. In other words, we can be taken to court. So therefore, that's fine. But if you just set up a working group, for example, for a particular project, and you put C in the circle, the working group, whatever project it is, the copyright wouldn't rest with that because that group would not be a legal entity. And like the Open University has a library, and the library produced some great work. And at times, they have put the C in the circle there. And we've had to say, well, you can't really do that because the Open University is the sort of responsible, liable institution. Although you would credit people who contributed, absolutely. But that's how copyright works. So I am the owner of copyright in this work. And by the work, I mean the entire card. So back to before we move on, back to our verse. Somebody said roses are red or whatever. These individual lines on their own might be what I call insubstantial. They might be too small to get afforded copyright protection. That's why we get into the habit of using small quotes and things. And people do generally know you can use small quotes because they would say they're not capable of copyright protection. If such small quotes were capable of copyright protection, it means you couldn't even use roses are red, basically, without permission. And every use like that would be like a risk decision. So they call that insubstantial. However, we have created a whole poem here, which the whole poem itself could be capable of copyright protection. And when I mentioned I own the copyright in the card, would I also own the copyright in that poem? Because I fixed it on the paper, would I? No, I wouldn't. The reason I wouldn't own copyright in that poem, even though I fixed it on the paper, is because you didn't give me an idea of a poem. You gave me the verbatim words. You said, roses are red, violets are blue, and all I did was actually record it. I actually just put it down. So I wouldn't, although I did contribute to that, I wouldn't be the author of that poem necessarily because you gave me the verbatim words. So it's likely that all the authors who contributed would be like, we would agree a joint copyright situation because we might think each individual line on its own is not capable of copyright protection. So we would agree there'd be, 3 or 4 authors there. The Act says in a joint authorship situation, it's there for when you can't discern one author from another. So therefore, if you're collaborating quite intensively and you don't know who wrote what, you might agree that's a joint copyright situation. Even though we know which line came where, we would, because it's so insubstantial, separate, we would agree probably that is a joint copyright situation. Does that make sense? Yeah? We don't have too much time, and I'll leave that for now. And any questions you can just raise, whatever. It just gives you an introduction. What I'm going to quickly do now is whiz through some slides in terms of explaining that more. And then I'm going to do a wee hand you out a wee exercise, and that'll open up the debate on Creative Commons. Is that okay? And we'll be ready for a cup of tea then, won't we? Okay. This is where I get stuck now.
I have one more question.
Sorry? Yes.
If we want to put, for example, a picture with people on it, and these people have a right? Because they can be recognized.
You mean if I took a picture of you and I
Yes,
used that
for
picture
example.
of you on the net? Basically, people do not have a right in their image as such. It's like how Princess Diana was hounded so badly. They used to just take pictures of her in their gym, whatever. And there is a privacy right which basically extends to where you would expect to be private, like in your home, and maybe at your wedding, and there's been a few cases about that and that sort of thing. But generally, you don't have a right in your image. However, in the business we're in, we're not the paparazzi, so you have to, I would suggest and advise you follow good practice. You would get people to agree for using their pictures. And as I say, if you have a waiver form, it doesn't take much just to get a signature.
One more question about images. With the Andrex puppy, what if I just got a bit of tracing paper and just traced over the photograph and turned that into an image, a cartoon or something? Does that become my own product then, or?
Well, if you use the Andrex puppy as inspiration, and I said there's no copyright in ideas, and say you traced it, and then thereafter the similarity ends because you're sort of adapting it to the extent that when your work's finished, totally unrecognisable from the Andrex dog.
It will look exactly the same, but just more like a cartoon.
Yeah, but
it would be to say, put it in Photoshop and put a filter on it and make it look like a cartoon.
Well, a cartoon could be completely different, couldn't it? A cartoon character.
I've got the same dimensions exactly.
Yeah.
So it could be. Different.
It could be. It could be that if you were coming to me and says, Bernie, can I do this? This is what I propose. I would say, yeah, but I'd need to see it. And then when I do, I look at the Andrex picture and I look at what you've created. And I would say, yeah, you're fine. So it's like a judgment that builds up like that. And you would know yourself. I think for those of you in the creative industries, you sort of know. You have that expertise and knowledge, and you know if you. But just tracing something, a map or anything like that, and more or less reproducing it exactly the same is not. Whether you've even put more work into it, is actually copying. So this is we've just gone over that with the card. I'll just go through them quickly. If you've got any questions, just ask. This is basically telling you what is protected by copyright. And the UK Copyright Designs and Patents Act is one of the most extensive in the world. When the world went digital, the Copyright Act in our country didn't even have to be amended. Other countries struggled because of the digitisation, but we didn't. So basically, everything you see there, if you're creating something that's not there, then it's not protected by copyright, and basically you can do what you like with it. But as you see, everything comes under the copyright banner: computer programs, databases, music, notation, etc., etc. And again, film, sound recordings, broadcast, typographical arrangements, performances and databases. We mentioned some of those. Typographical arrangements is an interesting one because that's where publishers get an extension on copyright basically if they republish Out of Copyright Works. So if you see Out of Copyright Works in a new edition, the publishers have got 25 years. So if you want to use Out of Copyright Works in their typo and everything, then you need to get permission. If it's a poem or something that's out of copyright and republished, I would advise you just rekey it and something like that. But unless they have adapted, obviously, the work in a new edition. And this is how long copyright lasts. It lasts for 70 years after the death of the author. I think it's a long time. However, I think it's a long time for software. For software to last that long when it changes week by week is ridiculous. But this is how long it lasts. Sound recordings, 50 years. If you're looking at the layers of music, etc., broadcasts, 50 years. But 70 years after the death of the author. These are the authors in a film. So they have awarded films for authors. So the last of these authors, 70 years after the last of these authors to die, that's how long copyright in a film lasts. However, if you're clearing footage, clips, that sort of thing, you don't need to really worry about that. You really need to go to the film companies that clear the footage. And when I say restricted acts, these are the acts that the copyright owner has, and these are the acts that we want to use unless we've got a license, like a Creative Commons license is what we pay for. Copying, storing, altering, and removing rights management data is as simple as taking off the copyright sign. That is illegal. Overriding security systems, obviously, is illegal, but you can't even override a security system to do an act that's legal. So, and there's more restricted acts, which is basically down centred round, I don't know, DVDs, that sort of thing, the illegal copying of that sort of business. When it comes down to authorising infringement, that's an interesting one, because that does apply to websites. If in websites you do not give proper advice to your users of your website, for example, if you're putting links into third-party sites and you do not advise them, the reason why you're doing that is just for ease of access only, that you're not authorising any illegal act they may do at that third-party site. So it's a bit of a disclaimer, really, you should have on your websites to avoid being seen to authorise infringement should your users go on to any third-party sites and get the notion that they can do more than they can. And that's what you can do. Insubstantial use, we sort of spoke about. Insubstantial use is not in the Act, but the Act says that a work or substantial part of a work is protected, so therefore you can use small parts without fair dealing, and we're not going into all of these today because we don't have time. And again, more permitted acts, which you can do. If you've got any questions on any of these later, you can ask me. Moral rights. The right to be named as the author and the right to object to derogatory treatment. And again, we're not going to talk about moral rights today, but it is an important one, particularly if you're adapting works. And indeed, even in the Creative Commons, they do say that moral rights are preserved, if you look at the Creative Commons license. So if you need to know more about moral rights, you can ask me. This is just a little table about, this is the process as I go through my head all the time to do with copyright before, automatically, is it a work, is it protected, am I performing a restricted act, do I have a defence, whatever. I just automatically use that all the time and in my head to make me decide if we can use or not these.
Is it a work? Is that as opposed to an idea? Like you were discussing before?
Well,
Not fixed.
when I mentioned before about all the categories of copyright, literary work, music, basically.
Those are works.
Those are works. And is it just a small part? And if it's just a small part, insubstantial, you may think, no, that's not a work. Use it. And is it protected? And if it is a work, then you'd be looking at, could be out of copyright, that sort of thing. It's still useful to go through a process rather than just jump to a conclusion in your head. And okay, we'll leave that there now. And we'll whizzy to our exercise. Okay. you'll have to go in maybe 4 and 4 groups. 4, just gather your chairs round. And I think, given the time span, you got 2 different ones. Yeah. Hey. I'll give you these. My colleague Alma Hales has just joined us. She is the head of IP here at the Open University. So you've got a good contact as well of any IP issues. And okay. Did you find that okay? Yeah, oh good. Shall we start with scenarios? The one where we've got 6 questions, okay? And this has I've got 6 images on the web from my course relay DVD. The resolutions are fine, however, they are available under Creative Commons Attribution Non-Commercial License. The clearance is fine for my use for our staff and students, but we probably hope to sell the course. Would you not bother with these images, and would you reselect?
Depends on how long it takes to ask for permission.
Pardon?
It depends on the delay you will have to ask for permission. No? Yeah. If you have time to ask for permission, then maybe you wouldn't change. But if you don't have time and you're in a rush, then you will reselect, I guess.
But you have got the images under Creative Commons license, which will fit your non-commercial use for your students. But you also know that this course is going to be sold. Practically, would you, knowing what?
I wouldn't use them.
You wouldn't use them?
No. Because you'd stop, as far as I understand it, my limited understanding, you wouldn't then be able to sell the course for commercial use because it includes these images. So you'd have to go back and find some other images later. It's wasting time.
Do the majority of you feel like that?
Yeah.
I feel different.
If you think you would sell the course in the form it's given to your students, I think you should treat them in one way. But if you know you're going to have to work on it to sell it further, that's when you address the licensing issue.
Yes, you could legitimately make that decision in terms of, I'm going to deal with one thing at a time. I'm going to use these images for our course, and if it's going to be sold 6 months to a year, I'll revisit it. There's that. But practically, and I've been there, whereby you've got the images for your course, easy peasy, and you did raise a point how difficult it would be to clear the images. It depends, because generally if it's a Creative Commons license, and generally easy to clear, and I know when I've cleared for wider use than a Creative Commons license, it's been relatively easy, because you can still wrap it up as an educational use. So I wouldn't ditch the dishwater. It's just, I'm not saying any decision you make is right or wrong. I'm just saying consider it fully of the issues before you sort of think, well, I'm not using them, because then you still have to reselect more images. Okay.
I can also add that the beauty of going back to a rights holder that's made their content available under a Creative Commons license is you are more likely to get free use.
That's true.
Because they don't think in a commercial way. That's not their raison d'etre. So it's always worth bearing that in mind before starting from point A over again.
Yeah, that's true, and I've done it. So it's just a business decision. Okay, we'll go on to. Right, we'll carry on with the scenarios. We are producing a social science unit for Open Education Resources area. A colleague from the School of Health and Social Welfare has provided some lovely images of children he took whilst he was away. I'm assuming because the colleague is a university member of staff, these images are okay to use in our OER area. What do you think?
Wrong.
Right. Why?
That person is the author and must in some way give clearance.
Okay.
It would be under violation of privacy rather than image violation.
In terms of?
Well, there's holiday snaps.
Yeah.
There's no permissions for the children.
I mean, that's right. One, there are his images, and maybe he has copyright in those images. That's something you should tick the box and have the checklist and make sure all the rights are in place. The other thing I was highlighting here is children. Be very careful in use of children, even if the picture is legitimate in terms of the copyright owner. Use of children on the web, for example, not only are you ticking a permission box, you're actually taking the image of the child itself is appropriate to your use, particularly with paedophiles, and you do not want to be seen as some repository to be added on that list for paedophiles. And children's images, and it's not something we're all expert in, even those that have children, but even full face images of children, just looking, it can be seen as provocative. So be careful in using images of children for activities. Use a side view or just their hands or something, but just have a checklist that deals with children's images and have some sort of policy going on for use of children's images.
That's an ethical way rather than strictly legal way, though, you mean, your advice? Because I had another lawyer's view that there was nothing illegal about that.
No.
Using children's images. So you're talking about in an ethical
Yeah, very
way,
much,
yes.
very
Yes.
much ethical. And I think when the institutions we deal with, as I said before, we're not paparazzi or anything like that. We have to put our ethics there with, I say, copyright or whatever. It's another tick in the box as to what sort of institution you are and what. Okay. I found an article by Alma Hales on the web, and this would be brilliant for my learning object intended for open use. I've tried to contact Ms. Hales twice and I've been in touch with the webmaster, but no response. I've amended it as I didn't agree with some of the points she was making. I think I've improved the work. I've obviously left her acknowledged as the author, and I've had no response, and I'm just going to use it. Everyone's talking about taking a risk. Is this okay? So what would you do?
You shouldn't leave somebody's name on a piece of work when you've actually put it isn't completely their work. And also you do need to get authority or permission.
There is, as well as an adaptation, which we didn't have time to go into, that's a restricted act. To adapt anyone's work, you need permission. But also there's the moral rights, which we don't have time to go into. And also, I'm not against taking a risk, and using a risk with a work is one thing. Using a risk and adapting it and putting it maybe in, amending it is sort of a big no-no. Yeah, thank you. You got that. Yeah. My institution is online open learn resource and it's based in the UK. We've selected an England and Wales UK licence for the use of our content. However, we've been asked by a user in China if the CC licence still applies. Does the CC licence refer to where the content is being used or to where it's being hosted? Yeah. The beauty of the CC licence is it is international, and I think some of the slides I'll show you. And even you might come across different, obviously international languages of a CC licence. You come to grips with those symbols. You don't really need to be fluent in any language. Those symbols convey the licence terms. And that's one of the beauties of Creative Commons license. And then if you're still not sure with the symbols, you can still go into the English version and think, oh yeah, that's what it means, I'd just forgotten. So yeah, the Creative Commons license is an international license. Some licenses, and quite a few licenses, have been adapted to fit the local laws, but that's just to take care of languages and nuances in the local language and how things are expressed. So, but yeah, good. I have some software I would like to make available under a CC license. Is that okay?
Under OS, under open source.
Yeah. Do you all agree with that?
So I didn't catch that.
I've got some software I would like to make available under a Creative Commons license. Is that okay?
But the thing about open source is that
Release it under open source.
open source is more appropriate for software. Is that the point?
Yeah.
Right.
Creative Commons is not really appropriate for software. Open source, there's lots of open source licenses, a GNU or whatever, and it's written to reflect software in terms of the source code and whatever, that sort of thing.
It's open source.
An open source license. Even on the Creative Commons site, it does, I think it does give you some advice on where you would go to license software.
Bernie, just going back to scenario 3. So the person's not responding. So what can you do?
Well, if the person's not responding, then you make a judgment whether you're a risk. In every business, you must have risk. Otherwise, you don't have a business, and an acceptable level of risk for your institution, which could be high, low, or whatever. But if somebody doesn't respond, it may be you decide, right, we're going to use Alma Hale's article. We're not amending it. And we'll leave her created as the, and you would put that maybe under the banner and await claim. So, in other words, you would wait out for Alma to come and claim, and that claim would usually mean a payment. So it might be, I'll put £100 aside in case Alma comes back. Generally, that's how it works. But that is a risk decision. Even though you've got a process in place, and you should have a process in place, that is a risk decision. It's not a permission. So,
Raise a point about number 3. Even aside from issues of copyright, that would just be bad academic practice anyway, to basically plagiarise someone's work or alter it in such a way that it's not theirs. Because you could use whatever material is in that article, if you use it artfully and you quote it and you show why it's relevant to what you're saying, it's not so much of an issue in a way. So it's about good academic practice as much as working within copyright legislation.
Absolutely. I think that's perfect, yes. It's always hand in hand with copyright legislation, yes, that's a law. But fundamentally, it is all about good practice. And you say you would never do that. I'm sure there's some people actually would do that. And but for most of us, we probably think, no, we might use the article as it is without permission, but we wouldn't go to the extent of plagiarising it, adapting it to the extent, and then leaving Alma's name on. Don't think so. But it does happen. Thank you. Right. My institution is making some of its content available under CC license. How do we ensure that our trademarks and our logos are protected?
Is that separate attribution?
You know, when you're making your content available under CC license, you generally mean the content. You do not mean you can take my logos and identity and reputation brands and use those as well under Creative Commons license.
So you don't specifically have to exclude them from the license?
Under a Creative Commons license, actually, they are excluded. However, it's not 100% clear, I don't think. But in all the advice about Creative Commons, it does not include that the license does not extend to use in the institution's trademarks or logos. And to reinforce that point, that should be in your use terms and conditions. So in your terms and conditions where you've got your content under Creative Commons license, you should really reinforce that on your terms and conditions to make sure that users are doubly aware that the content is not available, that doesn't refer to the logos, etc. Okay, now the other one, did you get this one done? Your educational institution is going to be working in collaboration with at least 2 educational institutions in the UK. You're going to create an innovative joint doctoral resource centre for PhD students in the social sciences. This facility will act as a provider of online resources. All institutions will provide some of their own existing materials which contain third-party content, journal articles, images, extracts, etc., and is made up from text and audiovisual content. It has been decided to leave irrelevant to the existing materials. Third-party content to ensure the context and the learning teaching experience of users is not greatly diluted. The existing content is 20 units of text containing 100 images and 10 hours of audiovisual content. The collaboration would like to make the content openly available whilst ensuring that their intellectual property rights are not compromised. So, how would you license this content to users? Would you consider a Creative Commons license? And if so, which one? Did you get this far? That's a bit of a mouthful I rewrote there, isn't it? Yeah.
I'm not sure what creative.
There
might be some Creative Commons licenses which will cover it.
Okay, well that's fair enough because we haven't really gone into the Creative Commons license.
Yeah. We were aware that even on Flickr, if you want to use an image on Flickr, there's about 3 or 4 different levels of Creative Commons just for photographs.
Absolutely.
So, yeah, we weren't sure the ins and outs of which one would be applicable in this respect.
Yeah, so that would be judged. This sort of scenario here is basically a reproduction of the OU's Open Learn. So the OU's Open Learn did exactly this. It actually put together the content, but did want to leave in the third-party content to sort of reflect the Open University's teaching material and to enhance the learning experience of the users. And they did, as you would know if you've been into Open Learn, they licensed their own material under a Creative Commons share-alike license. The third-party material in that repository is not available under a Creative Commons license, but it is available to use within the context of the content. So whilst you can take the OU-owned material and reuse it under Creative Commons license, if you want to keep the third-party content in, the users need to keep the whole package together and use the whole package in another way, in another educational way. What they can't do in the Open Learn scenario is take the third-party content out of that context. It actually works very well in Open Learn. And the reason we put it in here is just if you're dealing in OERs or you're dealing with making material available, you can sometimes think outside the box. You can sometimes think it doesn't have to be one or nothing. It doesn't even have to be one type of Creative Commons license. Increasingly now, people are saying you can choose. If you're putting content into a repository, for example, if you're in that sort of business, maybe like Score, you can choose a type of Creative Commons license that you're willing to make your material available under. And I think we've worked on some repositories in the OU like that. So basically, in any of your resource-driven projects, just think outside the box and think, right, what do we want to achieve? What's our objectives? And I think Andy did a very good talk this morning on explaining all of that. In that, basically, the learner is always up here. So, and I think if you keep thinking the learner comes first, what do we need for our learners and objectives? You know, there's always a solution, I think, anyway. And when I said, would you need to consider one type of license? Well, you could. Yes, you could genuinely consider one type, more than one type of license. Creative Commons is brilliant. And what would you need to take care of contractually in relation to the content? Well, for the third-party content, you would obviously need to clear it for that open use, which at the Open University we have done quite successfully. We've cleared the third-party material. Didn't cost us too much money in relation to everything else. And you'd be surprised of the good spirits that actually exist amongst rights owners for such, if your project is that good and warrants it. People are very giving. And how would you ensure that the integrity of third-party content is maintained? How would you ensure that the integrity of the third-party content is maintained?
Correct attribution, folks, in the originals.
Yeah, yes, you would. And again, your terms and conditions and your terms of use. So I've still got some slides.
Sorry, would you, with this one, would you,
Oh,
because it's a group project, isn't it? There are different institutions.
sorry.
They're sourcing their own material. Would you contract with them so that your institution owns the copyright and then did the Creative Commons license? Or would each of the institutions collaborate and take ownership of their individual bits?
If you're collaborating with more than one institution, there's usually what they call a host institution, and depends on the whys and the wherefores. The host institution could own the copyright to anything that's created in relation to that project. Those same institutions, when they bring their own material into that project, obviously, on the face of it, they would maintain copyright in that. But that's not always a given either. Indeed, when it comes to talking about copyright contractually, there's all sorts of parties coming forward to say they all should maintain copyright, and basically whatever works. Contractually and managing the contract, it's always better if one party has the copyright, even if the content is licensed out widely for use in any absolute way that they want to. But I say they do argue about it. Yeah.
It is the first thing I would look at
Yeah.
to make sure there was a contract in place. So yeah, it's the right way to think. Start at the top and work
Yeah.
down.
Yeah. Before you get to work, as we said with the card, get all that work done, and then everybody's arguing about who owns what. I'll whizzy through these slides, and then I've got time for that, Jonathan. We'll have a cup of tea. Okay. Again, Creative Commons, and I think Andy as well talked around some of the issues. It is becoming a standard, based on collaboration and interchange, and Andy very much better than that slide, put in his slides the benefits of Creative Commons, or indeed sharing. And indeed with Creative Commons license, moral rights are preserved. Creative Commons, there's different types of licenses, as we sort of intimated, and basically choose the one that's appropriate for you. Whether in any Creative Commons license, you've always got to attribute the author. Whether you want variation, no variation, a non-derivatives license, sometimes you'll see on the Creative Commons website, and I would encourage you to go and look at the Creative Commons website and get to grips with all the symbols. Whether you want commercial or non-commercial. This is with a view to actually looking at Creative Commons as well as making your content available under Creative Commons license. Lots of academics, strangely enough, don't want their content up there under a share-alike license. Quite often they want it under a non-derivatives. They just want to put it up there to be used, but they don't want it adapted or anything like that. So these considerations is something you can mull over. And again, as I said, you don't have to plumb for one type of license. Why do you? Whatever fits. Internationally recognised symbols is what we said. And these are just issues that you need maybe to be sorting out when you're looking at putting content under Creative Commons license or whatever. Basically, ownership of content created in-house. Are you sure that all that content that's created within your institution actually the institution owns? Maybe, but I think it's something on your checklist that should be ticked off to make sure that the institution does own it, does approve of what you're doing with it, and it's not actually owned by the academic author. Moral rights, again, that's an issue. Licensing of the third-party content, which we spoke about, and business models and what is non-commercial, particularly in educational institutions, where perhaps, I don't know, you're selling your courses, or the Open University sells its courses. Could you still sort of sell that as non-commercial if you're a non-profit making institution? I don't know. But it's not as straightforward as you think, but it's useful when you're talking to rights owners and explaining what sort of institution you are. As Alma said, they get there, sometimes they don't consider your activities as commercial. And again, collaboration, which we briefly spoke about in terms of licensing, creation and publication of content by users. What is open content? Again, I don't think I need to go through that much. This is basically indicating, and I think our colleague said open source, that generally refers to software. Open content generally refers to text and multimedia. Open courseware, MIT, open education resources, and the Open Learn is there. Copyright and open content. Yeah, copyright is retained. Creative Commons license is literally that. It's a license. It's not giving away copyright. It's just giving away a right, and all the other rights are reserved. Standardised licensing, and it is community based. And again, Andy Lane went over lots of these issues this morning. Standardised templates, Creative Commons on their website, easily identifiable symbols, and I say the beauty of the symbols is that they are international. It doesn't matter if you come across a license in Chinese, you recognise the symbols and you know exactly how you can use it. And their licenses are expressed in legal lay and computer languages. The beauty of the licenses is it's taken away all that lawyers being involved in the licenses perhaps we can use within an educational context, and they're written in an understandable language. So you have a short form that basically lays out what you could do, and then a longer, more legalistic form. And in that respect, it's sort of brilliant. And again, it doesn't challenge copyright, it just challenges the business models. And they're just options for Creative Commons as to what you choose for your project, or indeed when you're looking for content. And all rights reserved is really, with a Creative Commons license, has changed to some rights reserved. And that's it. Ratty whizzy whiz through, and I hope you got something out of that. Thank you very much.